I'm Tom Porter from the Office of Communications, and on behalf of the Office of Alumni Relations, it's my great pleasure to welcome the Thomas Brackett Reed Professor of Government, Andy Rudalevige. He'll be leading a webinar and Q&A dealing with a very timely issue and drawing on a forthcoming article written with Rudalevige's former honours student Victoria Yu, which will appear in Presidential Studies Quarterly in the September 2020 issue. The title of today's discussion is Pandemics and Presidential Power.
All right. Well, welcome to those of you who are here. My name is Andy Rudalevige, and hopefully you can see and hear me. I'm not in control of the technology. Like the railroad, it rides upon us. But nonetheless, want to welcome you all. Make a quick note that closed captioning is available for this event. So down on your Zoom menu, you should be able to access that if you want it. I'm going to jump over to some slides. First of all, of course, to note that I am coming to you from the basement of Hubbard Hall on the beautiful Bowdoin campus. And there we are. I'm hoping at this point you can see me somewhere on your screen as a thumbnail video. But actually, if you can't, I'm coming to you from my basement bunker here in Hubbard 23 and spent an awful lot of time down here since March. And the campus shut down. Again, welcome to this event on presidents and their power in public health emergencies, specifically the current pandemic, but we can think more generally than that. And of course, we can think too about ways in which we would want to think about broader questions of presidential power. And I'll try to leave plenty of time for questions and answers that can certainly go into broader considerations of presidential power and politics. I do want to make sure that as we get started, I give a shout out. Tom already did this to a degree, but want to give a shout out to a particular Bowdoin alum who I'm hoping is on the Zoom call here. Victoria Yu graduated in the class of 2019, won college-wide awards, won a departmental award for her honors thesis. Now working out in San Francisco, will be entering Harvard Law School, I think a year from this fall. And she was good enough to write with me a article that we had to pull together pretty quickly for obvious reasons, entitled Pandemics and Presidential Power. That will be in Presidential Studies Quarterly in September. So I want to make sure I take this opportunity to thank Victoria and to urge all of you with the power to do good things for her to do those good things. In any case, let's get started. I don't need to remind you very much, I suspect, about the circumstances in which we find ourselves. This is yesterday's New York Times COVID tracker, so it's about 24 hours old. But even then, of course, the United States had crossed the 4 million case and 150,000 death threshold. That, of course, has led to renewed intervention, involvement at the presidential level, as President Trump has renewed, at least intermittently, the task force press briefings that he held daily for a while back in the spring. And of course, I don't know, we went by quickly, but the original slide actually showed the broader, the original meetings. He's standing up there with Vice President Pence, and you can see the press kind of crowded in. Now, of course, much more separated. Most people wearing masks. You can see down at the left-hand corner of your screen, the president's press secretary, who's not. But in any case, the briefings continue, and they do naturally associate these issues with the president directly, and that's the kind of question we might want to ask. Where does presidential emergency authority come from? Well, there are two answers, and perhaps only two, really. It's a short list. One is the Constitution. Right? What are emergency powers in the Constitution? And even if you believe in a certain inherent emergency authority, and people will look, for example, to Abraham Lincoln's actions during especially the opening moments of the Civil War, even that kind of inherent emergency authority, I would argue, needs a constitutional framework. right? So there's no emergency powers that just exist literally inherently. They have to be present in the form of governance. The Constitution itself is notably short on specifying emergency power, and especially outside of wartime, many scholars have suggested that there isn't much of that, right? That domestic authority is really through delegation. So number 2 on the list, the law, right? It could be specific delegation where emergency statutes are created that form a framework from which presidents can fill in the details during a particular emergency. And we'll talk too about general delegation. When I think of as the residue of the administrative state, the kinds of things that arise from the fact that we have a very large national government, a very large bureaucracy that does many things, and that delegation of power from Congress to the executive has been a constant of the last, now almost 90 years of American history, and that has aggregated and accreted into, again, what we might call the administrative state. If you're in a bad mood about it, you might call it the deep state. But in any case, authority that is granted to the president and to the executive branch generally to act. And I will say that almost all statutory delegation is broad and broader than some, and yes, me, would prefer, but we'll come back to that point. When we're thinking about public health emergencies, we want to think about emergencies generally, and then again, specifically those related to public health. The first list is longer than the second. I'm going to talk in fairly rapid fire fashion about 5 key statutes that we talked about in some detail in the paper, and which are, I think, the most important ones to consider in this context. And again, I'll go through them individually, but they constitute the National Emergencies Act, the Stafford Act, the Defense Production Act, the Public Health Service Act, and then a variety of acts which are collectively often called the Insurrection Act. There was an Insurrection Act back in the early 19th century, but there are other things contained, I think it's in Title 10 of the US Code, dating to 1792. Think about the Whiskey Rebellion. And the ways in which the national government reacted to that in the late 18th century. Those are the kinds of laws we're talking about there when it comes to reacting to domestic emergency. All right, so why don't we look through what these do? The National Emergencies Act, well, we've heard something about this. It was actually passed now 45 years ago to rein in the states of emergency that existed at that time, and which actually dated to the Great Depression. Those were then added to by World War II and other perhaps slightly less pressing matters, the international economic crises of the early 1970s, for example. But Congress in 1976, as part of its broader resurgence against unrestricted presidential power, again, this reaction was prompted largely by Watergate and by Vietnam, that was put in place to rein in these existing states of emergency and to set up new ways of allowing the president to tap into emergency powers. Created a new framework for declaring new emergencies and for unlocking powers that existed in statute and that could be effectively unlocked by presidential declaration. Unlike the earlier power to declare an emergency, you had to be, as president, specific about what powers you wanted to use in which law. By far, the largest percentage of emergencies declared after 1976 are in the economic area, and there are laws that are used to impose economic sanctions on particular nations, sometimes particular individuals, perhaps most famous or infamous of the current emergencies, and there are still over 30 in effect today. So if you're feeling beleaguered, there are 30 plus national emergencies in effect. Of course, the most famous or infamous is the border emergency that was declared in early 2019 as the president sought to unlock funding effectively for the border wall that Congress had declined to provide sufficient funding for as the president saw it. So that emergency also remains in effect. You may have noted that there is a procedure for Congress to overturn these declared emergencies, but it's a little bit difficult because Congress has to pass a resolution overturning the emergency. The president can veto that resolution. So in effect, a veto-proof majority is required, and thus far, at least, Congress has not mustered that with regards to the border wall. So those are in effect. The only time this law had been used for public health was in regard to the H1N1 swine flu emergency, and President Obama issued a proclamation in 2009 invoking the National Emergencies Act. President Trump did basically a carbon copy of that in March 2020 using Proclamation 9994. If you want to look it up on the Federal Register page. It effectively, as Obama had done, waived some restrictions on Medicare in the Social Security Act, dealing with billing, dealing with the kinds of things that could be reimbursed, and allowing generally more flexibility for hospitals and other healthcare providers receiving Medicare to act more flexibly, to be able to do more things without worrying about reimbursements immediately and so forth. So that is a relatively limited use of the National Emergencies Act, unlike the invocation of emergency for the southern border wall, the president's invocation for the pandemic in March has been pretty uncontroversial, I would have to say. Law number 2, the Stafford Act. This is what we think of as the FEMA Act, if you will, the Disaster Relief Act, and it dates, well, disaster relief dates way back in American history, but the key elements of the law as it stands date about to 1950 in the Federal Disaster Relief Act. They were trying at that point to avoid having to appropriate funds for every single disaster that members of Congress were begging money for in regards to their constituencies. The Stafford Act is named after Senator Stafford, so the version that we're looking at is from 1988. One thing it did was to clarify emergency versus disaster declarations, and interestingly, the latter was defined as a natural catastrophe, earthquake, hurricane, etc. Those are the kinds of things that the disaster part of the Stafford Act was designed to provide fast cash for. And interestingly, of course, largely the use of the act has been for those kinds of disasters. There are a handful of times where we could look at a public health use of the Stafford Act funding. The Love Canal in New York, some of you will remember from the 1970s, more recently in Flint, Michigan, given their drinking water crisis. But on the whole, these are limited, and they tend to be very geographically specific and quite expensive, right? So it's where a state or locality is effectively overwhelmed by the need to act in response to a very particular environmental emergency. So the COVID crisis is actually the first national emergency declared by the president under the law, that is in every part of the United States. There had been emergencies declared under the law by the president, but these were things like the Oklahoma City bombing response back in 1995, or the reaction in, say, Arlington and Alexandria, Virginia, near the Pentagon in 2001 after the September 11th attacks. So this was not originally requested by governors. The president declared this outright at the same time that he declared the broader emergency in the National Emergencies Act. And by mid-April, though, the administration had requested and received numerous requests by governors, by territorial assemblies, from Native American governance bodies, and then wind up now with 90 local emergency, 56 local disaster declarations are in place, all dealing with COVID. The key element of this is that it opens up a lot of cash, right? This is cash that can go to the federal government from the, to the states or localities involved. And again, government sometimes does this well, sometimes badly. Hurricane Katrina comes to mind in the latter case, but it is a fairly well-established mechanism for funneling money to areas and industries that need relief. One thing it does do, and we can talk about this more, is to elevate FEMA somewhat in the hierarchy of disaster response, right? President Obama did not invoke the Stafford Act back in 2009, dealing with H1N1 or regards to Ebola, partly because it does shift FEMA into a slightly more advantageous bureaucratic position that might not be appropriate, right? President Obama felt it was not, President Trump felt it was, but it does shift FEMA slightly up in the rankings over, for example, HHS or the Center for Disease Control. Another act that you've heard a lot about dealt with the Defense Production Act. This is originally passed in 1950 as sort of a sequel to the War Powers Acts that were passed during World War II. And that, again, some of you will remember, imposed very strong national controls over economic output production allocation. The Korean War, coming just 5 years after the end of World War II, sort of reawoke some of those authorities. And it has been authorized, all the way up to 2018, I think was the last time. So this is not even though it was inspired by a specific conflict, pretty major war, now it's used in relatively routine ways. The Department of Defense actually invokes it hundreds of thousands of times a year, believe it or not. DHS, Department of Homeland Security, via FEMA, more like 1,000 times a year. And this is basically to prioritize contracts. What the Defense Production Act does when invoked is to require businesses to accept and prioritize government contracts, and it allows government to provide resources to expand production or to allocate needed goods. You might have seen, for example, the Kodak just got a big loan, $750 billion-ish loan from the federal government to begin to do pharmaceutical development, right? Something they haven't done, but that's necessary. That's a loan rather than a grant. Grants are possible. There was some early reluctance on the part of the administration to invoke the DPA in the current crisis. The president said that we're not a shipping clerk, we're not a country based on nationalizing business, but ultimately it has been utilized. The Congressional Research Service keeps good track of the number of contracts involved in this, but you will have heard certainly of those orders designed to facilitate the production of ventilators, for example, personal protective equipment, maybe a little more controversially, meat processing, again, back in the spring, and now the Kodak loan. But there are things also regarding the use of funding awards for microelectronics, even rare earths, things that are not necessarily related to the COVID crisis are still being used now under the DPA, again, on an ongoing basis. But again, this is designed to move the government to the front of the line when it comes to the production of certain materials, designed to coordinate the distribution of those materials. And again, this can be done well or badly, and we've heard complaints about the latter when it comes to especially coordinating the distribution of personal protective equipment earlier in the crisis, masks, perhaps most notably. The Public Health Service Act, well, the clue is in the name. This is actually specific to public health, which the others are not. And the others are sort of, again, not generally brand new to think about public health with regard to those other authorities, but the Public Health Service Act was specifically passed in World War II to expand federal quarantine powers. And they're very worried at that time. Remember the 1918 influenza had come out of army camps and the like. They were very worried about the spread of infectious disease. And so there was an effort by the Roosevelt administration to effectively get the states to accept more federal power when it came to, again, organizing, coordinating, controlling the spread of infectious disease. And again, and now coming up on 80 years, this has been reauthorized, sometimes updated, sometimes expanded. You may be glad to know that in 2006, there was a Pandemics and All Hazards Preparedness Act passed. You may or may not remember the important stress that was placed on biodefense and worries about public health in the wake of the September 11th attacks and the anthrax attacks that turned out to be unrelated, but at the same time, effectively. And so a lot of worry about bioweaponry, about using chemical or biological warfare. And so it was felt necessary to make sure that the public was prepared to respond to any sort of public health emergency. Again, playbooks were developed that haven't necessarily been used, but a lot of planning was done in the mid-2000s, and then again later on 2009 and 2014 or so, when the H1N1 and then the Ebola virus were at issue. There's actually quite a lot of authority in the Public Health Service Act, delegated mostly to Health and Human Services, to CDC, again, the Centers for Disease Control, to the Surgeon General. And in fact, the head of HHS, Secretary Azar, was the first to jump on this federal authority. He declared a public health emergency January 27th, 2020. It's been renewed a couple times, most recently just last week for 90 days. That authority under a public health emergency does allow regulations to be issued that grant control effectively of infected people, especially those who are a threat to cross state lines, which could be almost anyone in a mobile age. Indeed, at the very end of the Obama administration, well, literally the last moments, January 2017, regulations were issued under this law, inspired by the Ebola outbreaks, to allow the quarantine and even the, quote, apprehension of infected individuals who might move across state lines. You will be glad to know that apprehended individuals do have to be fed and given medical care, but it's actually quite striking language. If you read through the regulations that have been issued as a result of the Public Health Service Act, they give the federal government a lot of power to control movement and the behavior of individuals who might spread infectious disease. The other place where this has been done, which I'll come to in a moment, has to do with immigration. At the moment, no use of the power to forcibly quarantine or to prevent people's travel has been implemented by the federal government. You might remember this tweet from late March where the president talked about a quarantine, capital letters, about hotspots. At that time, New York, New Jersey, and Connecticut. Of course, things have shifted geographically quite a lot since then. But this was presumably the authority to which the president was referring to try to prevent people from moving across state lines if they were infected. Again, as I mentioned, while it hasn't been used in this regard, it has been used to quite dramatically limit immigration. And again, the law and the regulations do allow the administration to invoke the threat of the spread of infectious disease to cut down quite dramatically on legal immigration. And that authority has been utilized aggressively by the current administration. The Insurrection Act, a little bit more fun, if any of this is fun, right? Because it does, of course, refer to the very tense question of when the United States can use force internally. And the idea, of course, is that if you have an insurrection, a rebellion, then yes, you should be able to prevent that. And so a collection of laws dating back to the 1790s, as I said at the outset, have been put in place in order to try to make these authorities a little more regularized and indeed controlled to a degree. The Posse Comitatus Act, passed in 1878, probably the best known limitation. The motives behind the Posse Comitatus Act were perhaps not of the most wholesome. This was really pushed hard by southern states who wanted the federal government to stop enforcing the equal protection of federal law during Reconstruction. And as you can see, it coincides quite dramatically with the withdrawal of federal troops from the former Confederacy after the end of active Reconstruction. And so the idea is that the federal government can't be used as law enforcement effectively, except in certain conditions. And the exceptions are, at least on paper, relatively broad. The state can request aid, of course, and that happens. But also, if the state can't or won't enforce federal law, this is federal law, not state law, by the way, that the federal law enforcement is supposed to be reacting to. In those cases, you would have the option for the president to federalize National Guard troops or use regular armed services troops and to enforce federal law. You saw this several times, starting really in the 1950s with the desegregation of Central High School in Little Rock, Arkansas, but other times when proclamations were issued saying that a state of disorder effectively existed and that therefore the president needed to use federal force. The picture that's on the upper right of the screen is actually federal troops being moved into the University of Mississippi campus, Ole Miss, in 1962 to enforce desegregation orders there in the Kennedy administration. Now, the last time this was used directly was in 1992, trying to restore order in Los Angeles after the rioting that followed the beating of Rodney King by Los Angeles police. Again, there was some speculation that these laws could be used to enforce a quarantine that was declared by Public Health Service Act authority. Right? You could imagine a situation where everybody was trying to flee to Maine as the one good place to be in the world, and that the Maine state police were unable to enforce a federally ordered quarantine against movement state to state. That would be a situation where you could possibly have a request or simply the federal government step in to provide extra personnel to prevent that kind of movement. Now, of course, it hasn't been invoked for COVID, but there have been, as you all well know, multiple uses of federal force during the reaction to the Black Lives Matter protests of recent months. Washington, Portland, Oregon, perhaps other places. The authority for these is a little bit distinct, but nonetheless, certainly a cousin of Insurrection Act type authorities. Again, I'm happy to talk more about broader questions of presidential power and to the degree that I can to answer questions about ongoing events. So you do have the Q&A option available to you down at the bottom of your screen. And if you do want to enter a question, I know that the good people in Alumni Affairs are going through those and trying to organize them in a way so that I can answer as many as possible in the time that we have. This, by the way, of course, is the president's not exactly invocation of this authority, but justification that you would expect, perhaps not in these words necessarily. The sick and deranged anarchists and agitators are, again, those who, in the president's view, are making it clear that the state cannot enforce or won't enforce federal law protecting federal property. In the case of Portland, at least that's the most specific justification for the use of that force. Okay, so there's a whole lot of other stuff. And again, I'll move fast here so we have time for questions. Feel free to ask about for more detail on any of this. But as I mentioned, there's a whole lot of administrative discretion vested in the president. Regulation and of course deregulation, the use of what are called guidance documents. These are simply memos or other documents produced by a particular department or agency, basically saying, here's how you should follow the law, right? Laws are vague, often they are contradictory. So how do you actually do it? Guidance documents in the past has been somewhere below official regulations in their hierarchy of authority, but there have been some efforts actually to sort of put them all on the same plane. In any case, there are lots of things the government does to tell you how to enforce the law, how a vague law should be read, how it should be enforced, and the president, through the agencies, to be sure, has a fair bit of authority over how that enforcement happens. Martha Durthick, the late great Martha Durthick at the Brookings Institution, the University of Virginia, used to say that when Congress can't pass new laws, all the attention is paid to new ways of interpreting old laws. And a lot of what I'm talking about here is about just that. New laws can't be passed, so you have to give new meaning to old laws. You can use emergency or temporary rules. Right? That's one way of moving around the requirements of the Administrative Procedure Act, for example, especially when, as you know, is quite clear, there is a national emergency. You can also issue waivers. Often that's granted in prior statute, right? The fact that the president or departmental secretary can say, okay, well, we are officially waiving a particular thing that you need to do. Standardized testing, for example, which is in Title I, ESEA, Elementary and Secondary Education Act, the most famous recent version of which was the No Child Left Behind Act. That allows certain parts of the law to be waived, and Secretary DeVos at the Department of Education did that. The EPA, Environmental Protection Agency, similarly has waived quite a lot of requirements during the current crisis, seeking to place less burden on business during this crisis. Waivers are more official. Non-enforcement is frankly just non-enforcement, right? We are not going to spend time trying to track down particular polluters in the EPA example. We will assume that you can't do some of the things that are necessary to do. And indeed, the president issued an executive order encouraging agencies to use sort of proactive declarations of non-enforcement in certain areas to smooth the way for economic recovery in the wake of the COVID crisis, though wake is perhaps not where we are right now. Procurement decisions, right? Government contracting is supposed to be done on a competitive basis, but there are provisions in the Competition and Contracting Act and in other places that allow you to shift around and to simply direct that a contract be granted to a certain provider, right? And we've seen that quite frequently in the current crisis, right? Moving around the bidding requirements in normal federal procurement law in order to move faster on certain issues. We've seen discretion in funding, right? The president's decision to withdraw funding from the World Health Organization was made possible by the fact that you had vague appropriations language passed by Congress that gave a certain amount of money to a whole bunch of international organizations, of which the World Health Organization was one of them. And that did not specify that a particular amount of money had to go to the WHO. So the administration was able to sort of zoom past. There was certainly, there were understandings. There was report language passed by Congress, but it wasn't in statute. And so the administration had some discretion in order to act to put forth its policy priorities, even when those had not been necessarily endorsed in statute. They weren't prevented in statute either. And that was an important thing to keep in mind. Again, as I said at the beginning, often these are discretionary authorities that are grounded in pretty vague language and sometimes very expansive delegation. Immigration is a great example of this. We've seen the last several administrations use their claimed discretion under the Immigration and Nationality Act to either do more or less enforcement of immigration law. But if you remember the so-called travel ban case, Trump v. Hawaii, decided by the Supreme Court in 2018, the Supreme Court read the language under which the president had limited immigration from various places and said that by its terms, the law, quote, exudes deference to the president in every clause. Well, Congress continues to exude that deference. They have not amended the relevant portions of the INA, and so the administration has been able to act, again, pretty aggressively to shut down legal immigration. Of course, that's included international students to a degree. It's included green card holders or new green card applicants. It's included even those coming over with work-based visas for the moment. And you may remember the president both broadened and extended that particular proclamation under the Immigration and Nationality Act not too long ago. After having said originally he was going to shut down all immigration, his first order did not quite do that. The second is closer, though again, limited in time, though it can be extended, and there's every reason to think it would be under most circumstances. Okay, so just a few more things. Where does the president have power? Well, the president has power to talk and to shape communications, the so-called bully pulpit, what Teddy Roosevelt termed the bully pulpit. Of course, meant bully and bully for you kind of sense. This is good. But the president pretty quickly figured out that it could also mean to bully in the sense of influence. And so if you think about the president's response to various state-imposed economic shutdowns, the famous liberate tweets of mid-April, right? Open up now, liberate Virginia, liberate Michigan, liberate Minnesota, and to try to pressure local and state decision makers to change the policies that they put in place or to back up those they hadn't. power of example is pretty important in the presidency, especially in a system where so much affective polarization, emotional polarization exists, where your actions are seen as a statement on behalf of your partisan identity. Of course, we see that most dramatically with masks, right? There's the president in Maine, in fact, in not wearing a mask quite dramatically, even though he's touring a facility that makes personal protective equipment, in this case, testing swabs for coronavirus testing. The swabs, as a result, had to be thrown away, those that had been exposed during this visit. More recently, though, of course, the president has been talking about the importance of wearing masks. His visit to Walter Reed Hospital not too long ago was the first time he had been photographed in public wearing a mask. And that was seen as a pretty important symbolic shift in terms of the power of example. And we also have, of course, the role of expertise, right? One advantage that the presidency has, it's not a formal statutory advantage, but the president has access to a whole bunch of information, right? From all corners of the federal bureaucracy, but also, if those are not used, from other people too, those who might be a little less reliable in terms of their medical advice. And so the president does generally get the benefit of the doubt when it comes to speaking with expertise. That's not always universally extended, though. It's something that has to be earned over time. And then finally, just to sort of remind you of the general weaknesses of the president, the fact that the president does have to rely on communication and on, again, symbolism in the bully pulpit, suggests ultimately a paucity of formal powers to control. You'll remember, perhaps some of you, Schoolhouse Rock and the three-ring circus of government. Richard Neustadt put it a slightly different way, talking about a system of separated institutions sharing power and therefore not in control of powers unilaterally. Federalism, of course, the power of states, is an important piece of that. And we have, of course, seen in the current crisis a lot of state-based response. States vary quite dramatically in their response to the virus crisis. You can see congressional pushback, right? Not always as quickly as some might like, but certainly the opportunity exists for Congress to shape a response through the way in which it legislates, or by default in the ways that it fails to legislate. Courts, of course, have been a very constant theme of, well, all regulatory policy in the last 20 plus years. The Administrative Procedure Act, I mentioned very quickly a slide or two ago. And that was important, for example, in the Supreme Court's decision about DACA and whether the president could roll back the DACA program without going through the process demanded by the APA. Many of the emergency orders that are put in place regarding regulation, deregulation, even non-enforcement will likely be challenged in court. And then these are not separate from, but part of the wider political dynamics, right? The president at different times has talked about having total authority. At other times he said, I don't take responsibility. Neither is exactly true, or at least both are problematic at the point of a national crisis, right? President clearly does not have total authority. A lot of authority does rest with states and with local governments. That said, presidents are expected in our system to take responsibility and to serve as at least the coordinating pivot point of a national response when you have a genuine national crisis. And it's on those kinds of bases that presidents are often going to be judged by the voters or by history. And so we'll leave that judgment to another time. But I did want to thank you all. I'm going to shift over to the Q&A section, so feel free again to put in your questions over there. I'm going to stop sharing this screen, and it looks like we've got about 20 minutes. I look forward to answering those questions with you. Thank you for being here. Okay, so I pull up Q&A. I'll see if I can take these more or less in order quickly. I'll expand that a little bit. So there are a handful here. So one question is about the National Emergencies Act, passed in the wake of President Nixon's transgressions. What legislation do you foresee the Congress enacting to rein in power now? This is a great question. There has been some talk about academics about, these are not necessarily only Trump-specific deliberations, but the broad growth of presidential authority and Congress's, frankly, failure to do much about it in the last several administrations, has certainly been a matter of discussion. I think we are thinking broadly about changes in the civil service, changes in the acting, in the Vacancies Act, right? Ways in which Congress can gain somewhat more control over appointments. I think certainly the activation of the National Emergencies Act with regards to the southern border made it pretty clear to members of Congress that they had designed that law poorly. Not entirely their fault. There's a Supreme Court case from the early 1980s that made it more difficult for them to overturn presidential declarations. But in any case, that's certainly an area where you have seen a little bit of congressional pushback, not least several votes to overturn the declaration, even though they did not overturn a presidential veto. And a couple things, I think it's called the Article 1 Act. It's one of these horrific acronyms that members of Congress develop. But it actually produced by Mike Lee, a Republican member of the Senate from Utah, who wants to at least shift the default outcome in the National Emergencies Act so that a national emergency to continue has to be affirmatively voted upon by Congress rather than simply extended by the president unless Congress can stop it. And I think that in areas of war powers is another good example where the war powers resolution suffers from similar structural infirmities. As I mentioned, issues of the civil service and government service, which is going to need to be reinvigorated as members of the career service just simply age out, if nothing else. There's going to be, I think, some attention to the sort of role that Congress could play in reinvigorating the kind of oversight role that it played in the 1970s. That said, that oversight disintegrated when members of Congress stopped paying attention to it, right? And whatever you think about the hearing with Attorney General Barr the other day, it's hard to see that as substantive, productive oversight generally, the kind of cooperative oversight you would need to really rework the congressional executive branch experience. So I do think there will be important shifts. Obviously, it will depend somewhat on the makeup of Congress in 2021 and the occupant of the White House. But I do think that perhaps even if the current majorities were to prevail in those areas, you might still see increased attention to ways in which Congress can act more. So I'll leave that. Speaking of congressional declarations, the president, as you may know, did talk today about postponing November's election. The president does not have the power to do that. Date of the election is set in statute by Congress. And in fact, in the Constitution, in the it's the 25th Amendment, maybe the 20th, it talks about the president's term simply expiring at noon on January 20th. And so it must be the 20th Amendment. And so frankly, even if there were no election, one would see a shift in the occupancy of the White House as of noon on January 20th, again, under the current constitutional structure. So I don't really, it certainly got people talking. The president has been, I think, a little bit dangerously enthusiastic about promoting what he sees as the dangers of voting. Absentee and mail-in voting has been used very widely in the United States for a long time. And there's no real reason to think that it's problematic. There's certainly no data to that effect. So, casting doubt on the legitimacy of an electoral outcome strikes me as imprudent at best. But the president does not have the power to shift that. It's probably not coincidental that tweet was sent, 15, 20 minutes after the really dreadful second quarter GDP numbers were released today. Question on check on powers from judicial and congressional branches, sorry, just reading aloud, when it comes to permitting more extensive presidential power under certain circumstances. Yeah, so there are areas, right? On the whole, I would say, in the COVID crisis itself, the larger complaint about presidential power is that it hasn't been used enough, which is not necessarily what you would expect. The president from time to time has talked about his absolute authority, has talked about how he's going to order states to open their economies or to allow in-person church services, right? There's certainly no shortage of presidential rhetoric on those notions. On the other hand, where you've seen, those haven't necessarily been followed through on, and indeed probably more responsibility than should be the case has been kind of dumped on, devolved to state governors. Governor Hogan in Maryland, right, sort of, again, famously / infamously had to go to South Korea to try to get a big supply of masks. And states were effectively competing against each other for that kind of material. And that is what something like the Defense Production Act was designed to stop. It was designed to smooth supply chains, and the Stafford Act and FEMA are supposed to serve, basically as the shipping clerk, right? That's actually not a problematic authority for the federal government to try to coordinate the supply of needed goods to where they need to go at that time. So, I think many folks in the disaster relief field thought that, in fact, to the degree that the administration did invoke DPA authority, it was has been too little too late, and that the kind of national attention that could be given to testing infrastructure or to a national testing and tracing infrastructure, right, that really didn't happen. And you can, we've seen probably the same, sort of blow-by-blow accounts in the New York Times or Washington Post that I have about the White House response. There clearly some early attention and then effectively not enough detailed attention, but that is the kind of thing that could have been happening at the presidential level, did not. I do think in the area, you will certainly find some interesting choices made with regards to regulatory decisions or non-enforcement decisions, specific contracts that were assigned, at least reputedly because a particular friend of the administration got a hold of Jared Kushner's ear and said, I can build those ventilators or respirators or masks or what have you, and then suddenly a federal contract goes their way. So that, you'll see certainly abuses in that way. And, there are certainly suggestions that in some cases the administration is using the COVID crisis, to achieve policy ends that it would have liked to do anyway, but didn't have a rationale for doing beforehand. And maybe, again, immigration might be the best policy area in which to point to those kinds of examples. Certainly there was a lot of background discussion well before the COVID crisis about how to limit legal immigration. And so having a reason to do it has been, I guess I would have to call it a blessing to at least certain people in the administration, if not to the country. The questioner also asked about the BLM protests, and I think that's a whole different world of authority, right, with regards to, again, national use of the police power. It's been I think the examples in Portland, for example, the use of the Federal Protective Service, to literally be doing arrests well beyond the borders of federal property. That's a little bit scary to me, and certainly not recently precedented. So there are some abuses there. They did to the, one of the, social media is not entirely good for the body politic in my view, but it does have the virtue of raising potential abuses. Sometimes they turn out not to be abuses, but here I think they did highlight potential abuses quickly. You saw something similar, in the backlash to the president's response to, Lafayette Park in Washington itself, and the very aggressive federal response to the protests there, culminating in the president's waving of a Bible. So I do think you have a There, though, I mean, again, it's not necessarily an institutional response so much as a strong political backlash, right, from public opinion, from other political actors, the ability of Congress, for example, to subpoena people to provide direct evidence on what actually happened in the Lafayette Square attacks, right, has shown that the original reports were at best incomplete, shall we say. So I do think there is, some hope in, sunlight as disinfectant in these areas. The other branches, though, I mean, ultimately, the cure for executive overreach is impeachment. And that is something, of course, we've seen already in this administration. But, to the extent that executive powers themselves are abused, impeachment is one issue, but statute can be changed. Right. And so whenever we're talking about executive overreach, I don't want to forget about congressional invisibility with regards to that overreach. Right. You can't really have an imperial president without an invisible Congress. You can't have Congress could shape the way in which these powers are legally used. On the whole, it has chosen to delegate broadly. And that, in a sense, is on them to a degree. So this actually leads to a different question, which is about the Supreme Court. Right. And whether the court itself has, upheld or limited executive powers under presidents of both parties. On the whole, courts try to evade the very big picture issues about presidential power. You've seen the court forced into really statutory interpretation with regards to things like immigration in the last few administrations. But generally, where it's possible for the court to evade, say, a war powers case, it's done so. It invokes the so-called political question doctrine. And again, not necessarily inappropriately punts that back to Congress, saying that if you don't like the way Congress, the president, is implementing the use of force, for example, you do have it within your power to use the appropriations power or other legislative authorities to rein in what the president is doing. What's interesting, and this you'll recall perhaps, was Article 2 of the Articles of Impeachment against the president late last year, early this year, had to do with obstruction of Congress, right? And the administration's declaration, effectively, that it would not give any information to Congress. A variant of that was then brought to the court, quite recently in the Mazars case, where there's a question of whether presidential business documents outside of the presidency can be subpoenaed. And as you'll have seen, the court didn't exactly punt. They said that Congress could get this information, but it would have to, ask in a more detailed way. It would have been very problematic, I think, for the court to rule the other way, say that Congress does not have the power to investigate. Because again, I think it's in the legislature, not in the courts, ultimately, that you'll get, serious systemic reform. The courts, make policy retail effectively, right? Congress makes it wholesale. So to the degree that the courts are going to weigh in on a lot of specific issues, environmental regulations, probably immigration law, but again, to the degree that Congress has set up broad delegations in statute, like in the INA, I think you'll see the courts largely ruling on behalf of presidential authority. And to be honest, presidents of both power have appointed people to the court who are vaguely favorable towards executive authority, people who have worked in the executive branch. And that's true, obviously, people like Justice Alito or Roberts, but also Justice Kagan, for that matter. So that deserves an even longer answer, but we'll move on. Other examples over the last 50 years or so of a president using the powers available to him during a health or other emergency as aggressively as Trump. Well, again, I think it depends what powers we're talking about. I think if we're looking at the health crisis, then yeah, I think there's room to argue that the president could have actually been more aggressive in invoking federal authority over coordinating the healthcare response to the pandemic and the sort of physical supplies that were needed. I very mistakenly, the sort of trope that there's always a tweet for that. Well, before Twitter, back in 2005, I gave a talk in Washington where I said that something like Hurricane Katrina, while a tragedy, would probably help President Bush at the time regain his mojo, because after all they had to do was to utilize the federal government to get a lot of stuff to the Gulf of Mexico area. And of course, they failed miserably to implement that. And there's lots of public administration cautionary tales to be drawn. But in a certain sense, right, the role of the federal government to provide stuff, the logistics side of it, should be the easy part, right, in a way. So that's a question of presidential leadership, also of the quality of appointees up and down the bureaucracy. But in terms of the was it used aggressively, not so much. I think where you see the real aggressive use of presidential power, we are seeing it, I think, in some of, again, the use of federal law enforcement in states, in cities that frankly don't want it, that haven't asked for it, that say, no, we are not incapable of enforcing federal law here. And foisting that on that is a quite problematic for federalism as well as for civil liberties. The other side is the use of the executive power generally, again, to seal off the presidency from oversight. And that's about information, it's about the use of the pardon power, it's about the use of the Department of Justice's prosecutorial discretion in many cases. Again, these are not necessarily brand new tools, but they are being pushed in a pretty aggressive way here. It turns out generally, and this is going a little bit to a different question as well, will the uses of presidential power in the current crisis have long-term consequences? Well, I think so, in part because of what we talked about before, which is the possibility of broad reform and Congress perhaps becoming serious again about restoring its own authorities vis-a-vis the executive branch. But presidents do learn from what their predecessors do. And they don't always have the same theoretical claims, right? President Bush, W. Bush, talked a lot about, the unitary executive and the inherent authority in the president to act in certain ways, especially in wartime. The Obama administration rejected that as a theory, but you'd be hard pressed to find very many examples of where the Obama administration was not able to find a law that justified whatever it wanted to do. Indeed, in Libya, it sort of read the War Powers Resolution out of existence by claiming that what was happening in Libya was not hostilities and therefore could not be controlled by the War Powers Resolution. So very generous statutory interpretation, right, was something used there so that the president would say, I'm not acting just on the basis of my inherent authority. I've been given this authority in the law. And again, we could go on for some time with this debate. It's the basic topic of my presidential power in the law seminar next spring. But the general idea that presidents learn what they can do and what they can get away with is absolutely true. And so, it's one reason that it's problematic for Congress not to push back when there are, the use of executive authority to, again, protect the president and really the person of the president more than the office of the presidency against efforts at oversight or accountability, right? And the allegations, largely substantiated, of efforts at least to do that by the Mueller investigation, to try to interfere in the investigation. The president was helped largely by the fact that his own staff saved him from himself, right? They were ordered to do something, they didn't do it. But presidents in the future may find staff that are willing to do even all of these things. So, all right, so I'm seeing from my minders here that we have time for one more question. And before I see what we've got down on our question list, I can't see them all at once, sorry. I want to thank you all again for being here, and just to remind you that for other events, for scheduling, for any way you want to contact the good people in the alumni office, their website is kept very much up to date. And they're going to be trying to schedule events like this to keep you in touch with your great alma mater. And I certainly am really pleased to have been able to share this time with you. So let me, so we have, let's see. Well, I'll see what I can do here in a very short answer to what's a great question. This is about the response to the crisis and the lack of consensus on the response and what that's doing to the Republican Party as a whole. This is tricky because questions of cause and effect are difficult. It's clear that one of the issues, and this is not just a Republican problem, but the members of Congress see themselves as working for the president instead of with the president. And that limits what you can do in terms of a policy response. You saw, for example, the attacks on Liz Cheney. You may or may not like Liz Cheney as a member of Congress or as a figure in history, but the attacks upon her were effectively for not being sufficiently subservient to the executive branch, which is a very weird accusation to be made in a congressional caucus hall, right? Historically, the idea was that the branches were separate and independent, right? That they have the power to push back. And so to the degree that the parties now see themselves as effectively instruments of the White House, either for it or against it, right, depending on where they stand, without really looking at specific policy matters is potentially problematic. But it does also lead to a kind of paralysis in the so-called governing party, right? When you don't have a president with a very clear vision of response, and you as members of Congress see your electoral prospects suffering as a result. So if you look at the Republican majority's efforts to craft a coherent new coronavirus response bill, Democrats in a sense have it easy. They put this big pile of cash on the table and said, you deal with it. We're going to run on it whether you pass it or not. And it is an awful lot of money, by the way. That's a whole other discussion question. Anyway, the question for Republicans ultimately turns into, what do we need to do to protect ourselves when the president has shown himself able to mobilize grassroots voters, the base, but not able to expand that base. And to be honest, hasn't tried very hard to expand the base. So this is a kind of a, I understand a rambling answer to a good question, one that perhaps doesn't have a very clear answer. But I do think that maybe we can end on a broad note, that the response of both parties to Trumpism is really going to determine how effectively the United States can be governed moving forward. Again, whether Trumpism ends at least as a governing force in 2021 or 2025 or another time, I think that is a reckoning that needs to be had in order to, again, establish a working two-party system, which you could argue we haven't had for a while, but which I would suggest we really don't have now. So on that very happy note, from the sunny basement of Hubbard Hall, I wish you all well. I thank you. I hope you're safe, staying sane. Delighted to be with you, and thank you again for joining us today. So with that, thank you and good night.